Do we have thumbs up? Surinder? Crikey. All right. Right. So, welcome, folks. We've just mucked up the green room, and I've been told not to swear because we're live, apparently. So, welcome. Welcome to your favorite part of the week. And you're thinking, what would I do without Thursday afternoon, 5 p.m. TPP time? Exactly. You know exactly what I'm talking about. And my assistant, I've mucked up my screen, so I'm not sure what you guys are seeing, but welcome. Let's get on with the show. We've got a special guest speaker, well, a favorite speaker of the show. And look, if you're a solicitor, you want to close your ears a minute, because solicitors can be problematic, but we found a good one somewhere. Don't tell her that. She's going to charge more for, she's going to give me a hard time for coming on. Anyway, look, I'm going to stop talking, and all I'm going to say is put down your colouring pencils, get your pens out, make some really good notes. I'm going to bring in the TPP's, well, don't tell the other guys, TPP's favourite legal expert on property matters. I'm going to try and stop talking. I know it's difficult for me. But Rima, over to you. And I know the first question you're going to ask me.
Please, can I share my slides?
I should have put that in the chat. I could have got a prize. Right, depends. Surinder, have you put enough 50Ps in yet?
They're all there.
Fantastic. Right.
Ready to go.
I'm going to be quiet. Rima, over to you, and looking forward to the Q&A.
Thank you very much, Dil. Thank you for having me, TPP, again. So today we are going to be talking about a topic which I've long postponed, but it's been overdue, arbitration and property disputes. So what we'll do is we will talk about what is arbitration, what are the benefits of it, and what type of property disputes can be resolved through arbitration. So let me just share my slide and my screen here. Right, okay. Right, share. Can everybody see the slides right now?
Yep.
Yeah, okay, fine. So most of you will be aware, my name is Rima Chu. I work for Blazer Mills Law. I'm a senior property litigation solicitor. I've got sufficient experience to be able to talk about what I'm going to talk about today, which is arbitration and property disputes. I'm also an accredited civil and commercial mediator. Okay, and those are my contact details there. This time I've just put down my email address. There's the work email address, and there is also my personal one. So depending on how formal your inquiry is and you want to reach out, you can do so. Right, okay, so arbitration and property disputes. Right, first of all, let me just start the slideshow. Right, okay. So arbitration, it's an alternative to litigation, as it means of resolving disputes. It's based on parties' agreements, so all parties must agree to submit a dispute, a particular dispute, to arbitration. And like a judgment, the decision of the arbitration tribunal is binding, and it is final, which is a little bit different to mediation, and that's something we've spoken about before. So how arbitration differs from litigation, it's usually arises from a statutory obligation. So now we will talk about statutory obligation a bit later on. We've got one in a particular sort of commercial rent arrears that have accrued from the pandemic. There is a government scheme, so something like that could be a statutory obligation to arbitrate. But mostly it arises on the basis of a contractual term that the parties have agreed to, the rights and obligations of the parties to arbitrate their dispute from an agreement that they may have entered into at the outset. And how else it differs is actually seat. So the parties will usually make a choice as to where they want the arbitration to take place. And that means usually the location, so where it's going to be rooted, because a lot of international arbitration is used to resolve a lot of international and cross-border disputes. So you can actually, the parties can decide where it's going to be based, okay? The agreement might mention that, but it doesn't actually have to be there. So the parties have to still have the freedom to be able to decide that seat. So appointment. So unlike litigation, where you don't get to decide what judge you have on the panel, you can have some input into the selection of the arbitration tribunal as to who you're going to have. The parties can decide that. It's entirely confidential. And also the decisions on the merits of the dispute of the tribunal and arbitration tribunal are usually final and not subject to an appeal, which can be the case in court judgments. Okay, there are exceptional circumstances where you can appeal an arbitration award, which is usually on a point of law, but the courts are very reluctant to set an arbitration award aside. Enforcement is also another key difference. The decisions of the arbitration tribunal are widely enforceable through different jurisdictions, and there are relevant conventions in place, such as the Singapore and the New York Convention, for example, that allow arbitration awards to be enforced in different jurisdictions. Okay. So Section 1 of the Arbitration Act 1996 is the most relevant and the most applicable one to keep things very basic and limited today. Is what is the purpose of arbitration? So the object of arbitration is to obtain a fair resolution of disputes by an impartial tribunal without delay or unnecessary expense, which can sometimes be the case when you go through courts. You end up spending a lot of time and it's quite costly, and you really don't have that control as to how far and when matters will resolve once you start the court process, unless you enter into an alternative dispute resolution method. The parties should be able to, should be free to agree how their disputes are resolved, subject to safeguards such as public interest. So, of course, the purpose of arbitration, again, is to allow parties to resolve their disputes as they wish to, without having to go to court. So now, many lease agreements make provision for disputes arising between landlord and tenants to be dealt with by arbitration, as opposed to going to court, and usually it specifies who the arbitrator can be, and quite often it's CIARB, which is the Chartered Institute of Arbitration Experts, or RICS, the president of the RICS. There are limited rights of appeal, as we've already mentioned, of an arbitration decision, and it can only be on a point of law once an award is made, and the court has the power to order a party to comply with the decision of an arbitration tribunal if one party decides to then later change its mind. Both parties to an arbitration will jointly and severally be liable for the cost of the arbitration process. So because it actually arises from a contractual obligation, you will decide as to, firstly, who is going to be on the panel of your arbitration tribunal, and then you decide when it's going to take place, what papers are going to be included in it jointly. So all of that process gives a lot of flexibility, and parties jointly have to agree at the outset as to what the costs involved will be, and they share them equally between themselves. So what are the benefits? So some of these things we may have already covered, but we'll go into a bit more detail. So benefits are confidentiality. So of course, as for example, in a court litigation, it may be open to public, whereas with arbitration, it's entirely private, and that can be very attractive to many parties, especially because if there are parties that are involved which are quite big PLCs, or if it concerns information that's quite sensitive. They don't want the publicity of the dispute. They don't really want the public or their shareholders to become aware of the issues in the dispute. It's quite a good method to employ. So it maintains that confidentiality. Flexibility, it's inherently flexible. So you can identify and agree with the other party as to who is going to be the arbitrator that's going to help you resolve the dispute. So for example, if it's a dispute relating to dilapidations claim, for example, in commercial premises, you may want to choose an appoint a building surveyor as your arbitrator. So it doesn't, you can actually choose a relevant expert in the field depending on what area it is that you're in dispute about. So certainty, of course, there are limited rights to appeal. So it gives you certainty that once an award is made, it's final and binding. Accordingly, an arbitrator's determination generally represents a more reliable endpoint for the parties than the decision of the court, which is at the risk of being overturned. If you appeal, of course, and there's limited right to appeal for an arbitration award. Speed, of course, it's generally quite speedy process. It's not forced by the parties, so they decide their own timetable. It's a contractual obligation, so depending on their own individual priorities and timescales, they can set how quickly the dispute is going to be resolved. Of course, subject to availability of that particular arbitrator. So generally quite a quick process. The fact that the scope to an appeal of an arbitrator's decision is limited means that arbitrations are usually done and dusted in quite much less time than a court process. So because you're in control of the entire process from the outset, you can generally dictate how long it takes to resolve that particular dispute. Again, it's quite a financially efficient way of resolving a dispute, because litigation can, of course, cost you tens of thousands of pounds. But if it's a £20,000 dispute, sometimes it can, going through court, it can become quite disproportionate. Arbitration, you can actually decide how much budget you're going to allocate to it and find an arbitrator suitable to that budget, and conclude the process in much quicker time frame and much cost effectively. And sometimes actually the arbitrator cannot make a decision on paper, so you may not even need oral hearing. Types of disputes that are suitable for arbitration. So landlord and tenant, these are the kind of disputes. If it's a claim for breach of covenant under leases, including damages and injunction arbitration, arbitrator can decide. Change of use, lease renewals, rent reviews, service charge issues, covenant issues, repair issues, and things like that. Anything arising out of a lease is usually suitable. I mean, they generally say any dispute is suitable for arbitration, but these are some of the examples that I've listed down. Easements and rights of lights, rights of ways, obstruction to right of way or extent of it, repairs to right of way, damages to loss of light, interference with light issues, general issues regarding extent of use of easement, drainage and water rights and things like that as well are quite good examples. Property ownership and interfaces, a boundary dispute, nuisance issues, breach of restrictive covenant between neighboring properties or lands, enforcement of restrictive covenant, discharge and variation of restrictive covenant. So that's all of the examples of disputes I've listed down, and I briefly touch on a very particular and most spoken about arbitration scheme which the government has launched following, and I think I've covered this in previous seminars, is the arbitration scheme to allow landlords and tenants to resolve their rental arrear disputes arising from the pandemic in commercial premises. So there is a mandatory scheme by which you have to refer your rental arrears which arose as a result of the pandemic to an arbitrator before you escalate it further and take any further action. So that commenced, and you've got 6 months to be able to apply for arbitration and refer your dispute. An arbitrator in that matter has got relevant many powers to make a decision as to whether they defer that payment, write some of it off, or consider payment schedules and so on and forth. So if anybody is at the moment suffering from a position whereby they have fallen behind on their rental payments, whether it's service charge, ground rent, or the actual rental payments in commercial premises, then of course do let us know, and then we'll be able to direct you as to how you can benefit from that scheme. And that's all from me.
Hi, Dale, are you asleep?
No, I was scribbling down. I was taking my notes. I was scribbling down furiously, and you caught me off guard. So short but great is the only comment I can make. So it's
Yeah.
short, to the point, and really useful. Surinder, I'm going to do something unusual. I'm going to let you go first with your questions before I go for it.
Right. First question that comes to mind.
By the way, I'm only going to give you 2, all right?
Oh, thank you very much indeed. You're too gracious. Is, as you said, in arbitration or in mediation, you get to a point who is in charge.
That's right.
What if the two parties don't agree on a person?
You can make an application to court, and the court can decide who the relevant arbitrator would be. Let's say some leases have provisions that if there is a dispute between the parties, you must go to an arbitrator. Now, if the parties can't agree, you can apply to the court, or you can go to the president of the RICS, often as quoted in many leases, who will decide who the relevant arbitrator would be in that dispute if the parties can't agree between themselves.
Yeah, fine.
Just sorry, Surinder, just to clarify, the president of the RICS Association can then nominate an arbitrator, right?
That's right, yeah. Most leases will have that wording, most modern leases will, but if the lease is silent on that issue, then the court can also decide. But you want to avoid that, because that's the whole point of going through arbitration.
It's not to get into the court process.
Yeah. I mean, it's a fairly quick process to actually have an audit as to who is the most suitable arbitrator in a particular instance. But if the lease is silent on that issue, most leases do sort of mention who will decide in the event of a dispute.
And what if the lease doesn't mention it? Is there a route to mediation in that one?
Well, yes. I mean, if the lease is silent, then it's really the parties' playground, really, as to whether if they want to arbitrate, they decide. If they can't decide who the arbitrator will be, applied to court, or there is mediation. That's always another option. There are without prejudice meetings. There's roundtable meetings. There are Part 36 offers. There's lots of ways in which a dispute can be resolved.
And in mediation, who decides who the mediator is?
The parties have to decide who the mediator is. So usually the parties' representatives will put forward or give choice of 3 or 4 mediators, and then you can elect which one is the most suitable one for you.
I'm going to give you. I'll give you a bonus question later on, Surinder, if you want.
Yeah, just let me finish on this one first.
This is one question. You didn't say it was a 3-part. Anyway, go
on. Now you put me off. I don't even know what I was going to ask. You carry on now.
That's fine. I'm off now.
Is that it? I don't get my questions. Come on, what's going on here? This is not fair. I want to go to arbitration. Right. Okay.
This has been Dill's topic from day dot. So
I'm going to claim a professional interest in this, right? So, can you do ADR, i.e., alternative dispute resolution, stuff like mediation, and exhaust that and then go to arbitration, or is it one or the other?
No, you can try both, really. If you're really trying to avoid court, there's nothing stopping you. You know, in fact, you can try any method. Courts encourage alternative dispute resolution. The courts are so busy at the moment. There's such a huge backlog. So yes, you can try mediation. It doesn't work, you could try arbitration, but it's very unlikely in practice that you would try mediation and then you would go to an arbitrator afterwards. You would then normally just feel that, okay, we know exactly what the other party's case is, where the impasse is. It didn't settle in mediation. We do need the intervention of the court. So otherwise you would opt for a arbitration panel from the beginning.
Yeah, so theoretically you could do both, but
yes,
by the virtue of its nature, once you do mediation, you're not going to go to arbitration.
Yeah.
So, Surinder, when your memory comes back, just jump in, right? So, is this a way of explaining arbitration? It's like court but cheaper.
That's right. Cheaper
and quicker.
Quicker, yeah.
And not sure, probably not better because the losing side can't wait appeal. Yeah.
Yeah. Interesting.
Right. Okay. Are your brain cells working up again, Surinder? No, he's the other. Right. All right. I'm going to keep going. I've only got 23 questions. So.
Oh God.
For the viewers, actually, let me ask you the other one first. So, I've heard lawyers and barristers say, even if you win in a court scenario, you only recover 60 to 70% of your costs, legal costs.
Yeah.
Is that idea, I'm not saying the exact percentage, but is that idea correct?
That's right, yeah. Yeah, you only recover about 60 to 70% of your costs, unless you apply for indemnity costs because there has been a very poor conduct on part of one side, depending on if it's two-party litigation. So unless there's real poor conduct, deadlines have been missed, wasted costs have been incurred, you know, you can ask for indemnity costs, and you can recover potentially higher than that. But usually that's right, 60 to 70%.
And you can refuse to answer this question because it's might be a bit intricate. So if in a court case one party makes an offer and the other one refuses, but then either wins or loses the case, their costs can be limited by that. Does a similar principle apply in arbitration, or have I got that principle wrong?
It's usually in court. So you're saying if a party makes an offer and then the other side fails to accept that, what are the implications of that? There's implications of that follow through in the court realm, whereas with arbitration you're going in to get a final binding decision of the party. So you can try to sort of tell the arbitrator if you agree jointly that's what offers have been exchanged or not. Usually parties wouldn't have already done that by the time they reach arbitration, or they may have done, and they might agree that we have to exclude that and keep it completely unbiased for the arbitrator to make a decision, because that's why we're going. But that general principle applies in court more. Yeah.
So arbitration is a different form of court, really.
Yeah.
You use the phrase jointly and severally liable. What does that mean?
So they're both liable, both parties are liable together for the cost of the arbitrator.
Yeah, so it's a bit like partnership, isn't it? I.e., if one party doesn't have the money and it can't be recovered from them, the other one will have to pay. Yeah. Great. Okay.
They're together liable for it. So
yeah,
normally they would share the cost of that.
And is that always 50-50, or is that up to the arbitrator to decide?
You would normally decide before that both of you are sharing the cost, and later on the arbitrator will make a final award as to who gets what.
Oh, okay. So the
And what the judgment is, yeah.
so the arbitrator decides really.
So you share the cost of appointment of the arbitrator, and then the decision is as it would be in court. So the arbitrator may award one party X amount of damages, and that may take into account their losses. That could be the arbitrator's fees, yeah.
And something interesting, you said that you can pick the arbitrator to suit your budget.
Well, it's budget and also expertise, really.
Yeah.
Because it really does depend on the value of the dispute. So you can pick, yes, you can pick a budget, and you can pick the relevant expert, yeah.
Okay.
Right.
If I missed out, who pays for the for the fees of the arbitrator or mediator?
Both parties.
Both parties. Now, the question I wanted to ask was, what if one party doesn't want to go to mediation or arbitration? What happens then?
Well, you don't go for arbitration because it's not a forced procedure.
Mhm.
It's either statutory because there's a government scheme or the law requires in a particular, for example, that commercial rent recoveries, the most applicable one in property arena at the moment, or it's a contractual obligation. So some leases might say, if there is a dispute, you must refer it to arbitration. If the party refuses, then that party is in breach of that particular contractual obligation to
Mhm.
arbitrate. Then it's almost like taking it to court to say, we must arbitrate and you cannot make a decision in court about this because there is an obligation on this party to arbitrate. So the court can make an order on the defaulting party to say you've got to arbitrate because that's what the contract or the lease requires you to do.
Okay, let me give you an example. On a lease extension, if the two parties can't agree on a figure, the marriage figure, and there is a clause in the lease saying arbitration can be done, can then the lessee force the landlord into that arbitration?
You can't force someone unless it says it's mandatory in the lease.
Okay, if the lease says that it is in case of a dispute, you go to arbitration.
It's mandatory, then
Yeah.
yes, you could seek to enforce that clause to say that this is a mandatory requirement and you are under a contractual obligation to arbitrate this particular issue. And if they refuse to do that, at that point, you may then wish to put an application to say, we need an order, an injunction ordering this particular party to enter into an arbitration process or engage in an arbitration process because this is the lease requirement and it mentions it being mandatory and they're in breach of that. If both parties, say for example, Surinder, there could be an instance where the lease requires you to arbitrate, but both parties overlook that and they both decide to go to court. Nobody's enforcing the obligation on the other. You move on. But of course, if it says it's mandatory and one party wants to and the other doesn't, you could seek to enforce that. It's like a contract.
Okay. Back to you, Dil.
I was trying hard to behave, as you can tell. This is actually, Surinder, that's a very good question. You almost nicked my question, almost. So, lease extensions, is that compulsory or is that dependent upon the lease? I'm just sort of clarifying something.
So it depends on the wording of the lease. If arbitration is mandatory or it's something that the parties will choose. The whole point of arbitration or any method of alternative dispute resolution is that you actually choose to resolve your dispute in a cost-effective and speedy manner. There is, if the parties are not cooperating, then of course they will automatically end up in court, whether it's to get a decision on the fact that we must arbitrate or whether it's actually on the issue of what the dispute is.
Yeah, so to paraphrase, well, to quote one of our previous guests, and it's not my fault because he said this word to word. Read the bloody lease, as Bernie said. Yeah. So if it says arbitration and it's probably to your advantage, you're better off going to it. Yeah.
Absolutely.
Yeah. And so it's interesting you mentioned government schemes. Boundary disputes was one of the things I noted that's on your list. Is that compulsory or is that by agreement, or how does that work? Because that's the biggest pain I come across, boundary disputes.
To be fair, I mean, I don't particularly in the arena of work that I do, I haven't had personal experience of engaging in arbitration for a boundary dispute. I'm not sure of schemes available. I know that there are mediation schemes available, but it might be worth, if anybody's looking to arbitrate on a boundary dispute, of course you can. There are expert surveyors who can make a finding and make a decision on that. So it might be worth seeing if there are any schemes the RICS or the Chartered Institute of Arbitrators are hosting or have got involved in, to see what's available. Otherwise, you can put an offer to arbitrate a boundary dispute.
But that depends on the other party, doesn't it? Accepting that offer.
Yeah.
So
you've got to remember, arbitration, unless it's contractually obligatory to engage in, it's a process that you opt in for because both parties want to save that time and money from the court process. So it's really not a forceful thing that you can make somebody do. The other party has to actually engage in it, and it's in your benefit. If somebody's reluctant to arbitrate, you've got the risk of the cost then, because they have to be shared. Then and then also the decision is made, it's binding. Then they try to make all sorts of exceptions as to why they weren't in the right sort of position to accept the arbitrator's award, or they try and appeal the decision in law and things like that. So it's not worth wasting your time and money to arbitrate unless the other party is in agreement to save that money and time from going to court.
So sorry, I might have missed something there. I must be dozing off. It's really too hot for me. Did you say that it's not worth going to arbitration sometimes?
It's not worth going to arbitration if the other party is not willing to, unless it's mandatory in your
right.
contract. Yeah.
So unless it's mandatory, they shouldn't do it, right?
You shouldn't do it if there is a dispute. You see, the questions that we've been discussing is, what if the other party doesn't want to and I really want to? Well, if the other party doesn't want to,
you can't make them
go down well with you anyway, is it? Because the whole point of it is it's voluntary. You opt in for it because you both want to save that time and cost of going to court and get a quicker resolution through an arbitrator. So if the other party is not playing ball with you per se, you wouldn't necessarily want to push it, and you would rather just go and get a decision possibly through another means of alternative dispute resolution. So you've got to both be willing to arbitrate in order for it to get fruitful results.
Okay, so unless it's specified, it's not another form of court, because court, you can end up there when one party wants to go to court. But
all right, so I see your point, Dill. So you can't just issue an arbitration notice and you have to comply, not unless it's a contractual obligation. You've got to both agree to arbitrate.
Yeah. So you can't force it on the other side.
You can't force it now.
Fantastic. Now, so I hear that the government is trying to put a process for resolving boundary disputes, and we're talking about. Boundary disputes are usually emotional. It's the piece of land is worth hardly ever any money. The costs of stopping a bad actor from taking over someone's land is is higher than the land's worth. The government are trying to come up with a similar law, that last I heard of, to the Party Wall Act. Would they be better off just saying every boundary dispute has to go to arbitration?
Arbitrator. In my view, it would have to actually be on the value of, because a lot of the times, you see, the court systems are inundated with boundary disputes which relate to very non-substantial parcels of land. So I think there's got to be a way of filtering which disputes go mandatory to an arbitrator and which disputes are more suitable. It's a bit similar to what you've got through the court process, small claim fast track, multi-track. So maybe a way of filtering which ones are the most suitable to go to an arbitrator mandatory, and then the other ones you actually have the option to actually decide whether or not you take it to arbitration, because I don't suspect, with the emotions involved between the parties, especially if it's a neighbor dispute, that they just want a court judgment. So yeah.
Yeah, so similar to a small claims court.
Yeah, which is a form of arbitration, really, because it's sped up. You know, you've got certain case management timeframes to comply with. Is much quicker, usually anyway. So yeah, I mean, I would, in my view, I think it'd be interesting to see how it's all implemented. When it's all finalized about the boundary disputes, and you know how they are going to be resolved in the likely future. But yeah, I think there's got to be a way of filtering which ones are suitable for it. Yeah.
No, it's so. You should be on the parliamentary committee for that, but they won't like it because it's like they can't create more work. Well, all your other friends, all your other lawyers will tell you off because you've taken away a chunk of their work. You know, I think the only people that like boundary disputes are the lawyers and the barristers, actually.
Well, actually,
sorry, I couldn't resist that one. I'm sorry.
I once had a client who, you know, was very emotionally involved about the boundary, and it wasn't really substantial, but it's a matter of principle for a lot of the clients when it comes to boundary disputes. And once you're in a situation, it's really difficult to come out of it and view it objectively, because before you know, you end up spending a lot of money. So in that sense, I think it would be heavily beneficial for parties to engage in boundary disputes when it comes to engage in arbitration when it comes to boundary disputes.
Yeah, so Surinder, take a clip of that and send it out to everybody, because that's really good advice, especially from a lawyer, and not a lot of lawyers give that advice. Sorry, I could. It's almost.
I'm the good one, you said, right?
You've just proved it. You know, I'm going off on a rant because I see this too often. You know, sorry, apologies. Surinder, any more questions from you?
You have exhausted me.
What, my questions or my jokes?
Your not only your jokes, but also restricting me to two questions only.
I'll tell you what. I feel bad now, and you know, I'll give you an extra question.
Don't feel bad at my cost still.
No, I wasn't feeling bad at your cost. I'm just pretending to feel bad because I want to look good for the viewers, right? Surinder, you could have an extra bonus question if you like.
Well, again, on arbitration and mediation, these are just dependent on if the two parties agree to go to that, unless it is mandatory. So really, they as we've seen, that the only few situations that they are mandatory in at the moment. Is that correct?
Yeah, I mean, of course, it arises, unless it's statutory, it arises in property disputes, which is what we're discussing today. Usually, property disputes, there are leases involved, and usually it's a contractual obligation, and most modern leases do have clauses to arbitrate in the first instance.
Okay, if we take the situation of light, restriction of light. Now, if I'm not mistaken, Dil, that is not a planning issue, but a legal issue. Sorry, I don't understand that, Dil.
There's three types of issue on light, from what I understand, right? So there's a planning light thing where the planners go by. There's also an easement on the right of light. And then you get, there's a third one, and it escapes me for the moment. It's the way the right of light works is you just get compensation if you're restricting someone's light and blah, blah, blah. Right?
Before we come to that, the planning issue, as I understand it, is not planning law.
No.
Yeah.
So the planners cannot refuse anything on restriction of light. Is that correct?
Were you asking me or Rima?
Either of you.
So when there is proposals, I mean, this is my understanding, and I'm sure Dil will correct me, is that when there is planning applications made and it's likely to obstruct with somebody's, I mean, naturally they take into account their surveyors in the council when they're considering planning applications. So they consider whether a building or an extension is going to obstruct somebody's right of light, whether it's implied or express. And then, of course, the neighbors or the neighboring properties are notified when there is a planning application and what the proposals are. At that point, of course, if you feel that there is going to be an obstruction on your express or implied right of light, there's very few that I know of, limited experts in the field, in the country, that can make an assessment on whether that is going to be the case. And then, of course, at that point, once you've got that report, you might want to present it to the other side and say, well, look, actually, we object to this on the basis of the findings. Or it might be very obvious, and you say, actually, we want to arbitrate on this particular issue because we've got this evidence and we're of the strong view. I mean, that's normally how the rights of right.
I mean, if I understand it right, if the planners have no right to refuse a planning application solely on restriction of light, because it's not a planning law.
So yeah, I mean, planning law isn't sort of planning law as such. It's all about UDP, and then it's a sort of different process. You have planning law that's permitted development, that's your sort of right to do things. You have planning policies of the local councils that can be overturned subject to appeal by the inspectorate at Bristol. So it's not firm sort of law. I'm sure there's other acts of planning. Now, particularly to the right light and the right of light question, the way planners decide on light isn't actually how the how the right of light operates. So they've got a different version of it, and a lot of it's made up. Then you've also got, and as Rima quite rightly said, there's probably about 2 or 3 leading firms, and they've almost got this market sewn up, or they're the leading experts, so nobody else can sort of enter this. And I've experienced it where I've recommended someone and he said, well, they're the guys that are advising the neighbor, right? So there's only about 2 or 3 of these companies. They do a weird calculation. They put a meter and it's 800 or 900 off the ground floor, room area, blah, blah. It's just like nobody almost understands this, and they'll come up with a figure. So in a sense, the council's stuff about right of light is a dumbed down or a poor man's version of that, but it's not enforceable. Then what happens next is council can give planning permission that still breaches a neighbour's right of light, and then they go and sue for compensation, right? With these guys who come in for meters. Actually, we should get a right of light expert in, because it's.
I'm getting there from the other side of it. If a planner refuses planning permission due to light restriction clause or whatever, then a dispute arises, and if they're challenged and appealed against, would that appeal have to go to the directorate, or can it be arbitrated?
I think it would go to the directorate. So Rima, as it's in
Yeah.
show about arbitration, let you have a crack at that question.
Yeah, so it would go to the directorate, and actually the council, it's a separate, the right to light, it's an easement,
Mhm.
right? So it's a separate issue, but the council has to consider that.
Mhm.
And then if the council's deciding, look, this is going to obstruct right of light for neighboring properties, or this is too obstructive, they will give their reasoning for it, and then you can appeal it through the general sort of appeal process. But generally in practice, what happens is this becomes more of a dispute once the planning permission has been granted.
Okay, fair enough. Thank you.
So it just to reference it to my area.
Council
Okay.
don't really have necessarily the right of light sort of experts, so they make the surveyors will make their own sort of assessment of it, and then obviously there is a reason for why you actually have the right to appeal if you feel that you're going to be affected by it.
All right.
Yeah. So planning, the interaction of planning and light is very much similar to party wall. Councils can give or deny permission, but they don't deal with that subject. It's interesting you talk about right of light, and I think they're using that same phrase, but in a different meaning or a different interpretation of it. So Surinder's understanding that you could, and your confirmation that you can appeal it to the directorate and let them decide.
Sure.
Yes, 100%. And then so the general principle to understand is, even if you get planning, it doesn't mean you can build it without consequences, i.e. you get planning, you still have to do party wall. You get planning, you've still got to deal with the right of light issues. You get planning, you've still got to deal with building control issues. So you might have planning, but that
Might not be
project
as
can,
specific and look into those things.
yeah, that project can potentially be unbuildable because of all the other issues that might go with it. So the way I sort of try and explain it to people is, think of it as a chest of drawers. Planning is one drawer. All the other issues are separate drawers, and you've got to do each of them separately, or a tick box. I don't know if
That's good.
it's like a checklist. You've got to check each of these separately that apply. Does that make sense?
Makes great sense. Yeah. Thank you.
All right. Wow, it's good, great subject. I've really enjoyed this one, actually. I've got sort of one last question, if I can sneak it in.
Sure.
Yeah, you talked about indemnity costs. Are you still there?
Yeah.
Yeah, you talked about indemnity. Is it indemnity costs?
Yeah. Mhm.
Is that to discourage bad actors in a court case?
Indemnity costs are costs above a standard basis, which is 60 to 70% because of poor conduct and unreasonable conduct, really, or taking a litigation to court, or wasted matters being litigated on. So it's generally sort of poor conduct on one party or the other that you can seek to claim indemnity costs, so higher than the 60 to 70%.
And
Punishment for acting badly, yeah.
is that done after the case is decided, or can you put in the application before?
After.
Oh wow, that's really interesting. Though I'm going to make that could be very useful for me in my professional. Right now, I've got something going on, so interesting.
You normally have a decision on whether the costs are going to be, the party is going to ask for standard or indemnity costs, and generally the court will see that at the time that you've got the decision, and then it comes to the issue of costs, and then you would have obviously asked for indemnity or standard, and then you would have given your reasons. There may be a separate cost hearing to decide who gets what and whether you get indemnity costs altogether.
Oh, okay, so you could have a separate hearing for costs.
Yes, you can do afterwards, yeah.
And is that normal, or is that not?
It depends if it's indemnity, then of course you've got to cross through more hoops than your standard when you're just successful and you get your 60 to 70%.
Okay, so one party's got to be successful, and then they talk about costs. It's really interesting. It's nearly, well, I'm going to say it's more
Normally,
interesting.
the winning party gets the cost, the loser pays.
Yeah.
Unless, of course, I mean, again, we won't get into it, but because it's very much dependent on the conduct of the parties. You could be successful against a claim that surrenders advancing, but just because you've won doesn't actually mean that you will get all your costs, because you could have acted really poorly throughout. You could have rejected offers that surrender made. So, you know, the cost could be shared, or you might not get costs altogether. So, you know, there's all sorts of implications, but the general rule is that the loser pays the winner's costs. Yeah.
So just to finish off on a property question, I promise this will be the last question, maybe. So the current, if you've got a commercial property and the tenant is owes you rent, you've got to go to arbitration, right?
If the arrears relate to the period when the restrictions, the government restrictions were in place, and their business was subject to closure as a result of the government restrictions.
So and what period is that, roughly?
So there were different periods during lockdown as restrictions eased.
Yeah.
So maybe we can have a chat about that deal, because you had full closure, then you could, for example, restaurants and hotels, you could do takeaways then. So it depends. And, you know, there's a strenuous exercise that you have to go through depending on what period the arrears relate to.
Oh, okay. So it's not really straight.
Not just, you know, you can't, I mean, because there were different periods of lockdown that allowed you to do certain things. So you've really got to get professional advice before you pull the trigger on this stuff, right? Yeah.
I mean, look, you know, it sounds.
The general rule of thumb is if you're in rental arrears because your business was closed down, or your tenant is in rental arrears because of their business being closed down by the government during the pandemic, then you can refer. You've got time still to refer your matter to arbitration.
And when does that deadline finish?
I believe you had 6 months, and it came into effect sometime in April. So you've got some time. I think it might be until September.
Okay, you've got till September, and
Don't
if you're
quote me on it, but I believe it's until September.
all right, we think.
Period, yeah.
And are we right in thinking that if you had, what's the situation if you've got two sets of arrears? You've got prior to the lockdowns, and
Prior
then
to the lockdown, you can enforce as normal.
yeah.
Okay? But anything during the lockdown period is subject to that arbitration.
Yeah, so just for our viewers, commercial rent enforcement's really quite quick and sharp. You can literally shut the door very, very quickly. I think it's 28 days or something.
Yeah.
Yeah, but
Every lease, of course, the starting point is, again, the magic word, read the lease. So, yeah.
well, what's the magic words?
Read the lease.
Oh, no. Hang on.
No, don't go down there, Dil.
Come on, you got to say it properly. We've got an expert who says that. Read the bloody lease.
Well, I cannot be swearing on live right now.
No, but it's not swearing if you're quoting someone.
Do not engage in such conversation still.
No, but it's like, because I'm quoting someone.
We're now going down a different route. Shall we just stick to our topic?
Sorry. Yeah. Well, come on, you're spoiling all the fun. Right. Any more questions, Surinder?
No, I'm fine. I'm done. I'm very happy. Thank you very much, Rima, for your
Good.
presentation.
Okay, thank you very much.
And Rima, what are we going to talk about next time?
I think next time, possibly not arbitration. Maybe we can talk about adjudication, because that's one topic we haven't covered yet.
Ooh,
yeah.
I'd never thought of that one. I was aware of mediation, arbitration.
Interested. I mean, I do. Yeah, I think adjudication is more something I've covered in practice with especially with construction disputes, is quite relevant. So
Okay, before you go, Rima, just last thing.
Ah!
Clarify what is adjudication.
No, Surinder, no, we can't do that. Hang on, wait. This is going to be a cliffhanger. That's for that program.
No, but
You can't ask for a definition. No, mate. If you ask for a definition,
yeah,
this is like cliffhanger.
I'm missing out one slide from my next talk.
Exactly. So look, no, don't give it. To all of yous, this is a cliffhanger. You know, you get LA law and you get cliffhangers. This is it. What is adjudication? Find out on Rima's next talk.
Next talk, absolutely.
Okay.
Yeah.
Surinder's totally unhappy. I think I might get sacked, actually.
Thank you, Dil. Thank you very
I'm
much.
going to Google
Thanks,
it.
Jai. And thanks,
All right,
Rima.
Rima,
All
truly,
right.
thank you very
Jai,
much.
Jai,
It
just
was a
stay on
very,
the
very
talk.
interesting program.
Sure.
Great. I'm glad
I'm going to
you
stop.
found
I'm
it.
going to stop the recording now.
Okay.
Well.
Right.